Hello Mark, I'm Mitch from the A class and my number is 39 and I'm going to read the article this week. Steve Wise, chimps have feelings and thoughts, they should also have rights. TED 2015. Filmed March 2005, subtitles available in 4 languages, viewed intervention transcript. I'd like to have you look at this pencil. It's a thing, it's a legal thing. And so are books you might have or the cars you own. They're all legal things. The great apes that you'll see behind me, they too are legal things. Now I can do that to a legal thing. I can do whatever I want to my book or my car. These great apes you'll see, the photographs are taken by a man named James Mollison, who wrote a book called James and Other Apes. And he tells in this book how every single one then, almost every one of them, is an orphan who saw his mother and father died before his eyes. They're legal things. So for centuries there have been a great legal wall that separates legal things from legal persons. On one hand, legal things are invisible to judges. They don't count in law. They don't have any legal rights. They don't have the capacity for legal rights. They are the slaves. On the other side of that legal wall are the legal persons. Legal persons are very visible to judges. They count in law. They might have many rights. They have the capacity for an infinite number of rights. And they're the master. Right now, all non-human all non-human animals are legal things. All human beings are legal persons. But being human and being a legal person has never been, and is now today synonymous with a legal person. Humans and legal persons are not synonymous. On the other side, there have been many human beings over the centuries who have been legal things. Slaves were legal things. Women, children were sometimes legal things. Indeed, a great deal of civil rights struggle over the last centuries has been to punch the hole through that wall and become to feel these human things through the walls and have them become legal persons. But also the hole has closed up now. Now on the other side are legal persons, but they've never only been limited to human beings. For example, there are many legal persons who are not even alive. In the United States, we're aware of the fact that corporations are legal persons. In pre-independence India, a court held that Hindu idols was a legal person, and a mosque was a legal person in 2000. The Indian Supreme Court held that the whole books of Sikh religion was a legal person, and in 2012, just recently, there were a treaty between the indigenous people of New Zealand and the Crown, in which it was agreed that the river was a legal person who owned its own riverbed. Now I read Peter Singer's book in 1980s. When I have a full head of lush brown hair, and indeed I was moved by it. Because I have become a lawyer because I want to speak for the voiceless, defend the defenseless, and I'd never realized how voiceless and defenseless trillions, billions of non-human animals are. And I began to work as an animal protection law, and by 1985 I realized that I was trying to accomplish something that was literally impossible. The reason being that all of my clients are the animals whose interested I was trying to defend were legal things. They were invisible. It was not going to work. So I decided that one thing that was going to work was at least some of them had to also be moved through a hole that we could open up again in that wall and begin feeding the appropriate non-human animals through that hole onto the other side of being legal persons. Now at the time there was very little known about or spoken about true animal rights, about the idea of having legal personhood or legal rights for a non-human animal. And I knew it was going to take a long time, and so in 1985 I figured that it would take about 30 years before we'd be able to even begin a strategic litigation long-term campaign in order to be able to punch another hole through that wall. It turned out that I was pessimistic. It only took 28. So what we had to do in order to begin was not only to write the law review article and teach classes, write books, but we have to then begin to get down to nuts and bolts of how you litigate that kind of case. So one of the first things we needed to do was figure out what a cause of action was. A legal cause of action. And a legal cause of action is a vehicle that lawyers use to put their arguments in front of courts. It's turned out there's a very interesting case that occurred almost 250 years ago in London called Somerset versus Stewart, whereby a black slave had used the illegal system and moved from a legal thing to a legal person. Well, I was so interested in it that I eventually wrote an entire book about it. James Somerset was an 8 years old boy when he was kidnapped from West Africa. He survived the Middle Passage. He was sold to a Scottish British man named Charles Stewart in Virginia. Now, 20 years later, Stewart brought James Somerset to London, and after he got there, James decided he was going to escape, and so on. The first thing he did was to get himself baptized because he wanted to get a set of godparents. Because to an 18th century slave, they knew that one of the major responsibilities of godfathers was to help you escape. And so in the fall of 1771, James Somerset has a confrontation with Charles Stewart. We don't know exactly what happened, but then James dropped out of sight, and enraged Charles Stewart then hired slave catchers to canvass the city of London, find him, bring him not back to Charles Stewart but to a ship, the Anne and Mary, that was floating in London harbour, and he was chained to the deck, and the ship was to set sail from Jamaica, where James was to be sold in the slave markets and be doomed to the 3 to 5 years of life that a slave has harvesting sugar cane in Jamaica. Well, now James' godparents swung into action. They approached the most powerful judge, Lord Mansfield, who was chief judge of the Court of King's Bench, and they demanded that his issue a common law writ of habeas corpus on behalf of James Somerset. Now, the common law is the kind of law that English-speaking judges can make when they're not combined in by statute or constitution, and a writ of habeas corpus is called the Great Writ, capital G, capital W, and it's meant to protect any of us who are detained against our will. A writ of habeas corpus is issued. The detainee is required to bring the detainee in and give a legal sufficient reason for depriving him of his liberty. Well, Lord Mansfield had to make a decision right off the bat, because if James Somerset was a legal thing, he was not eligible for a writ of habeas corpus only if he could be a legal person. So Lord Mansfield decided that he would assume, without deciding, that James Somerset was indeed a legal person, and he issued the writ to habeas corpus, and James' body was brought in by the captain of the ship. There were a series of hearings over the next 6 months. On June 22, 1772, Lord Mansfield said that slavery was so odious, and he used the word odious, that the common Law would not support it, and he ordered James free. At that moment, James Somerset underwent the legal substantiation. The free man who walked out of the courtroom looked exactly like a slave who had walked in, but as far as the law was concerned, they had nothing whatsoever in common. The next thing we did is that the non-human right project, with which I found then began to look at what kind of value and principles do we want to put before the judges. What values and the principles did they imbibe with their mother's milk? Were they taught in law school, or do they use every day? Do they believe with all their heart? And we chose liberty and equality. Now, liberty right is a kind of right in which you are entitled because of how you are put together, and a fundamental liberty right protects a fundamental interest and a supreme interest in the common law, the right to autonomy and self-determination. So they are so powerful that in a common law country, if you go to the hospital and you refuse life-saving medical treatment, the judge will not order it forced upon you because they respect your self-determination and your autonomy. Now, equality right is the kind of right to which you are entitled because you resemble someone else in a relevant way, and this relevant way. So if you are that, then because they have the right, you like them. You're entitled to the right. Now, courts and legislators law line all the time. Some are included, some are excluded, but you have to. The bar minimum you must. That line has to be a reasonable means to legitimate, and the non-human rights project argues that drawing a line in order to enslave an autonomous and self-determining being like you're seeing behind me, that's a violation of equality. We then searched through 80 jurisdictions. It took us 7 years to find the jurisdiction where we wanted to begin field our first suit. We chose the state of New York. Then we decide upon who our plaintiffs are going to be. We decided upon chimpanzees, not just because Jane Goodall was on our board of directors, but because Jane and others have decided chimpanzees intensively for decades. We know the extraordinary cognitive capability that they have, and they also resemble the kind of the human being have. And so we choose chimpanzee, and we began to then canvass the world to find the experts in chimpanzee cognitive. We found them in Japan, Sweden, Germany, Scotland, England, and the United States, and amongst them they wrote 100 pages of affidavits in which they set out more than 40 ways in which their complex cognitive capability, either individually or together, all added up to autonomy and self-determination. Now these include, for example, that they are conscious, but they are also conscious that they're conscious. They know that they have a mind. They know that other have minds. They know they're individual and that they live. They understand that they live yesterday and they will live tomorrow. They engage in mental time travel. They remember what happened yesterday. They can anticipate tomorrow, which is why it is so terrible to imprison a chimpanzee, especially alone. It's the thing that we do our worst criminal, and we do that to chimpanzees without even thinking about it. They have some kind of moral capacity. When they play economic games with human beings, they spontaneously make fair offers even when they are not required to do so. They are enumerate. They not understand numbers. They can do some simple math. They can engage in language or to stay out of the language wars. They're involved in intentional and referential communication in which they pay attention to the attitude of those whom they are speaking. They have culture. They have a material culture, a social culture. They have a symbolic culture. Scientists in the Thai forests in Ivory Coast found chimpanzees who were using their rocks to smash open the incredibly hard hulls of nuts. It takes a long time to learn how to do that, and they excavated the area and they found that this material culture, this way of doing it, this rock has passed down for at least 4,300 years through 225 chimpanzees generation. So now we needed to find our chimpanzees. First, we found two of them in the state of New York. Both of them would die before we could ever get our suits filled. Then we found Tommy. Tommy is a chimpanzee. You see him behind me. Tommy was a chimpanzee. We found him in that cage. We found him in a small room that was filled with cages in a large warehouse structure on a user chair, a lot in central New York. We found Kiko, who is partially deaf. Kiko was in the back of the cement storefront in western Massachusetts, and we found Hercules and Leo. They are two young male chimpanzees who are being used for biomedical anatomical research at Stony Brook. We found them. And so on the last week of December 2013, the Non-Human Rights Project filled 3 suits all across the state of New York using the same common law writ of habeas corpus argument that had been used with James Somerset, and we demanded that the judges issue these common law writs of habeas corpus. We wanted the chimpanzees out, and we wanted them brought to save the chimps and the tremendous chimpanzees sanctuary in South Florida, which involved an artificial lake with 12 or 13 islands. There are 2 or 3 acres where 2,000 chimpanzees live on each of them, and these chimpanzees would then live the life of chimpanzee with other chimpanzees in an environment that was as close to Africa as possible. Now all these cases are still going on. We have to now yet run into our Lord Mansfield. We shall. This is a long-term strategic litigation campaign. We shall, and to quote Winston Churchill, the way we view our cases is that they're not even the beginning of the end, but they are perhaps the end of the beginning. Thank you. Applause. Thank you for your listening.